All right, I think what I'll do is I'll kick things off. And if people are still jumping on, that's fine. We can get them jumping on that link. Good morning, everyone. Thank you so much for taking out your time today to join us for today's webinar. We have a rather important employment law updates, like Mato has mentioned earlier. The webinar is based around employment law updates in Singapore, and we are just so excited to present this and bring this to you all. Now, I just wanted to say that my name is Sanam. I am the Employment Counsel here at Employment Hero, and I am joined today by our two amazing speakers. We are basically now the Singaporean Dream Team. That's what I'm going to call ourselves, because we'll be bringing a lot more webinars to this space, so definitely watch out. Mato, Kotwani, Elizabeth, Wong, thank you so much for being here today. Could I get a little bit of a background about you and what you do at PD Legal?
Thank you, Sanam. Hello, everyone. Again, really excited to be here this morning. My name is Mato Kotwani. I'm a partner at PD Legal. We're a full-service firm, a mid-sized firm based in Singapore. We've got offices in Bangkok as well as an Indian desk and a Malaysian desk. So we are full service. Our bread and butter is in disputes, but we have a robust employment practice as well and an advisory practice. I've been in practice for about 7 years, and I'll leave it to Elizabeth to introduce herself a little bit.
Hi everyone, I'm Elizabeth. Thank you Sanam and Mato for introducing us. I think I won't delay any further on introduction. I'm a new associate to the firm, and I mainly work with Mato. And yeah, I think that's pretty much it. I'm very happy to be speaking here today, and I'm really honored to be given this opportunity from Employment Hero. Thank you so much for organizing, and I look forward to sharing with you all what we have prepared today.
Oh, thank you so much. Thanks so much to the both of you. That's really lovely. I think this is, like I say, dream team, match made in heaven. We're going to have a great time with this webinar, and definitely there is a lot of expertise, as you can say. We've given you double the trouble in terms of the expertise, so we'll definitely be getting a lot of good experience and understanding of these different areas. Before we fully get into it, I just wanted to do some general housekeeping while we're on this slide. Please know that there is a box at the bottom of your Zoom screens which we have basically opened up because this is a live Q&A webinar. So we will have time allocated at the end for you to ask any questions that we can answer while we've got the presentation and webinar running. Also, keep in mind as well that today's session will be recorded, so please don't frantically be worrying about writing everything down. We will definitely send out the recording, any additional materials, as well as the slide materials as well, because like I said, the information that we've got in there is quite good. And Elizabeth, if I could pop over to the next slide. I just wanted to do a quick disclaimer. This disclaimer is just to say that, look, these are our views. We are providing this to you in good faith. Obviously, this is not legal advice, but the benefit of having two amazing lawyers here from PD Legal is that you can definitely reach out to the law firm and ask them any questions if you're dealing with a personal situation as an employer-employee, and like Mato has said, even advisory service, which is great. So I will leave all of their details in the last slide, and that will be up for a while. So you can definitely, jot the details down, or we'll send them to you afterwards as well. So we'll jump into the next slide, and that one is just going to be a list of what we're going to be talking about. Look, I won't go into too much detail. I think you probably want to hear from the people that are the experts when it comes to the law, but we will cover some changes that we may have discussed last year, as well as focusing on some key changes that are going to come up. There is a raft of different changes, but we wanted to focus on maybe three key ones for everybody to understand, and then from there we'll go into our Q&A. So we'll kick off with the first part, which is the key updates. And if you joined us for our last webinar, you would have seen definitely that there has been changes across the landscape, but we always need a good recap of what happened last year and then what's to come this year. So Mato, Elizabeth, if I could get you guys to kick that off and start and let us know what's been happening.
Thank you, Sanam. As Sanam has mentioned, the key topics for today will be firstly the progressive wage model, the changes to Compass, and the new workplace anti-discrimination laws which will be coming into effect. But before that, as Sanam has mentioned, we'll just quickly recap some changes that have come about last year, or which are going to come into effect this year. Now, firstly, parental leave for fathers. This used to be 2 weeks. However, that has now been extended to 4 weeks for fathers of children born in Singapore on or after 1st January 2024. The additional 2 weeks of governmental paid parental leave are voluntary, meaning employers who are able to do so can grant the additional leave and will be reimbursed by the government. Second key update, unpaid infant care leave. Now, unpaid infant care leave has been increased from 6 days a year to 12, and all parents of Singaporean children are eligible if they have worked for their employer for at least 3 months. This is, of course, applicable from 1st January 2024 to working parents with children under 2 years old. Now, the third quick update would be the CPF contribution. Now, the CPF contribution salary ceiling will be raised from $6,000 to $8,000 by 2026, and this increase will be carried out over 4 years starting from 2023. I'll just jump right to the next one, overtime pay. Now, for overtime pay, there was actually a case that was recently decided in the High Court. This is Hossein Rakib and Ideal Design. Under the Employment Act, an employee under Part 4 cannot work more than 72 hours per month. So for under Part 4, this covers workmen earning not more than 4,500 and employees earning less than 2,600. The High Court clarified that if the employer forces the worker to work more than 72 hours, the employee is still entitled to claim for all the excess hours worked. Next up, we have medical insurance coverage for foreign employees. For anyone with foreign employees, take note that there is now enhanced medical insurance coverage for all work permit and S-Pass holders. And insurers must co-pay medical expenses up to a limit of $60,000 rather than $15,000. And this implementation began in 1st July last year, with the second phase coming on 1st July next year. Next up, we have the PWIC. This stands for Platform Workers Work Injury Compensation Network. Now, this has been set up by the MOM, intending to overhaul the process for reporting work injuries, claims processing, and computing income loss compensation. And additional recommendations for representation for platform workers by the tripartite work group were accepted by the government on 12 July last year. Next up, the MAST. This stands for Multi-Agency Workplace Safety Task Force. And this is a holdover from the enhanced workplace safety period we had during the COVID pandemic. It was set up advisory guidelines for workplace safety with a focus on encouraging reporting unsafe situations and also working actively to reduce workplace fatalities. There is an ongoing timeline for implementation of measures and guidelines through June this year. Finally, later this year, there will also be some new tripartite guidelines published to push for more employer leniency towards flexible work arrangements. So do keep an eye out for this. The next key update would be that of progressive wages. This progressive wage scheme encourages employers to pay a higher rate to employees with certain wage bands with co-funding from government. And with the push for progressive wages in mind, the government actually launched 3 additional progressive wage models in new sectors last year. Food services, administrators and drivers, and waste management. Slowly, you will begin to see each sector having more mandatory wage increases introduced. And as you can see from the slide, generally these are soft introductions with scheduled increases over a few years, which gives the employer time to implement them. For the food services sector, as an example, by March 2025, the progressive wage scheme will see an increase of up to 19% across the board for the lowest salary bands. And it's also important to note that the government is pushing for clear career pathways and mandatory skills modules to be completed by employees in this sector in order to justify wage increases and highlight the need for personal development. Just going back to the government's push for progressive wage actually culminates in the progressive wage mark. This is an accreditation designed to reward employers who take part in the progressive wage credit scheme. This mark can be applied for on the MOM website and is going to become an important feature of businesses going forward, specifically where government involvement is concerned. It is intended to be a badge of honor for the brand for both B2B and B2C reputation. And all employers who pay at least one employee the progressive wage scheme are eligible to apply. It's also key to note here that since March 2023, the government has required all its suppliers and subcontractors to obtain this mark for the duration of the contract. So if you do have any businesses with them, it's very, very important to make sure that you're applying for this ASAP. For any employer who adopts the further recommendations in the tripartite standards, there is an even higher version of the mark called the Progressive Wage Mark Plus. And with that, I'll actually now pass the time to Mato to cover the changes to Compass.
Thank you very much, Elizabeth. So we're going to move on to the next topic, which is Compass. And I think most of you will probably be familiar with Compass. This was introduced back in 2022. And this is essentially the framework which will govern all new employment pass applications, right? So from September 2024 onwards, it will also govern all the renewals. If we could go to the next slide. And this year, 2 new criteria were added to the Compass framework to allow for both potential candidates and local businesses to earn more points towards importing skills-based labor. So if we look at the tables on the slide, we see that so there's a visualization of the Compass model, and we see that there are both individual attributes as well as firm-related attributes. And then you can score points on both these attributes. So in relation to the candidate side, the individual attributes, right? It's primarily based on their salary, their qualifications, and from this year onwards, they will also obtain a bonus for being on the skills-based shortage list. And then for the firm-related attributes, we have diversity, which is very important. And this is something to bear in mind, because we will see how diversity, the government is really, and MOM is really focused on increasing diversity in the workplace. So later when we move on to the new skills-based bonus and strategic economic priorities bonus, we will see diversity feature in these 2 considerations as well. So if we look at the 2 new criteria, right, based on internationalization, and employers can obtain up to 10 extra points per year not per year, but per application. Can we, go on to the next slide. So we'll talk a little bit about the skills bonus. And in addition to what was mentioned previously, right, points are also weighted based on diversity factors, is what I was talking about earlier. So if the share of candidates' nationality is less than 1/3 of your organization's PMET, you score 20 points. If it's more than 1/3, then you only score 10 points. So to just illustrate this, to make it a bit easier to understand, right? So we've got 2 candidates, candidate A and candidate B, and both of them are on the shortage occupation list. right? But your organization already has many PMETs from candidate A's nationality. Then you only get 10 additional points. But if contrast, your organization has very few PMETs from the candidate's nationality, then you score 20 points. Okay, so that's essentially what it means and how diversity factors into the skills bonus as well. Important to bear in mind that MOM will do background checks on all applicants, including job duties, past work experience, qualifications, industry accreditation, and so forth, right? So another thing to bear in mind is also that employers cannot redeploy workers who obtain their EP using the SOL bonus points to a different job. So in the situation where you've employed someone and you rely on the SOL to score more points, right? And then exigencies happen, circumstances change, you need to redeploy this worker. Employers will have to reapply to MOM, and then MOM will reassess the application and the candidate for that new role. Okay. Now to talk a little bit about the SEP bonus, and this is criterion 6. So criterion 6 is the firm-based bonus, which allows businesses to earn up to 10 additional points for each applicant. The thing to bear in mind is for the SEP, your firm or your company has to be supported by a sector agency or the NTUC. So for example, you need to be supported by EDB or IMDA, and I mean there are several agencies, and you need to participate in one of the programs run by MOM to support and develop the local workforce. Now, when you apply and if you get the SEP bonus, the bonus will last for 3 years. So once you get it, it applies for 3 years, and then afterwards you will be required to meet certain other criteria for diversity and local employment support in order to maintain that SEP bonus. So essentially, these criteria ensures that organizations eligible for the SEP bonus points make efforts to diversify and improve their workforce profile, right? So I think what the government is doing is to hand out the SEP bonus to qualifying employers first, with the expectation that the organization, the company will, over time, within that 3 years, factor in and improve on the diversity quota as well. So that covers the SOL and the SEP bonus. We do want to spend some time talking about the new anti-discrimination laws, which the government and the tripartite workforce has been talking about. You probably would have read about it in the news. This is going to come into effect in the, well, from what we know, in the second half of this year, although no clear timelines have been given yet. Okay, so essentially, this is going to affect all businesses with more than 25 employees. And likely in the future, this will apply to smaller businesses as well. From what we can see from the tripartite guidelines and the messaging, right, that has been shared, they will be reviewing this in the next 5 years. So we can expect that, and that's how Singapore typically does it, right? When we want to roll out new legislation, new laws, we, especially in the employment context, you know, it is typically applied to organizations that can stomach it. So the bigger organizations first, and then we improve, we tweak it, and then over time apply it to the rest of the industry, smaller firms as well, essentially to give businesses time to adjust. So, like I mentioned, we would expect it to come or to develop in the second half of this year. And it will be based on 20 accepted recommendations from the existing tripartite guidelines on workplace fairness and equality. Some of you may have already had some interaction with this and gone through the guidelines, but essentially it is based on these tripartite guidelines. So along with the implementation of these rules, there will be penalties as well for companies that are not compliant. So it's really essential to understand how the new legislation will work and what it means for internal processes. So since the tripartite committee began to implement guidelines for workplace fairness, it has had quite a positive effect on discrimination in employment. So as you can see from the slide, which is up, we can see that insofar as perceived discrimination in job interviews is concerned, it's down by almost about 20% in the 4 years leading up to 2022. And for resident employees, perceived discrimination is even lower than the EU average. And the intention of the new structured framework is to build on this progress, provide new authorities and remedies to deal with grievances, and formalize the procedure for employees who want to make a claim. So again, what we have is perceived discrimination. What we don't know is, of course, there will be a difference between actual discrimination and perceived and what is reported. But I think it's fair to say that the general trend is that it has been coming down in the last couple of years. But the government and MOM want to continue to improve on this. And I think that is why we see the implementation of these new or the efforts to implement and formalize the framework into law. Okay. So to understand what authorities are attempting to target, I think it's important to first understand what exactly the definition of discrimination is within the legal context. So as you can see from the slide, the definition is essentially making an adverse employment decision because of any protected characteristics. Okay, so this means that any decision taken in the course of business, whether it involves hiring, retrenchment, promotion, or even vacation day approvals, any decision that is made against the employee could fall within this framework, this banner. So this is why it's vital to understand the protected characteristics and ensure that from a business perspective, whenever decisions are made, or rather whenever any adverse decisions are made, it is documented accurately and fairly. You don't want to be in a position where an adverse decision has been made and then the employee challenges that decision on the basis of discrimination. Interestingly, it only covers adverse employment decisions, right? So one concern, or rather one interesting point is that what about in terms of decisions which are not adverse? What about positive employment decisions which are made because of protected characteristics? What about promotions made on the basis that someone is of a particular sex or race? That will be interesting because it doesn't really fall within the definition of discrimination, although all the other employees, I suppose, would be able to say that they have been discriminated against because that promotion was, for the other employee was made on a basis of a protected characteristic. And they were not promoted, perhaps, because of the fact that they did not share the same protected characteristic as the individual was promoted. So again, interesting, but I think it is important to follow not only the black letter of the law, but the spirit of the legislation as well, right? Okay, next slide. So we come to, we've seen what the definition is. Question is, what are protected characteristics? And we can see from this list, there's age, gender, marital status, pregnancy, race, so on and so forth. So really not many surprises with most of the protected characteristics. Probably the protected characteristics which will likely generate quite a bit of complaints will be language. And the statistics show that most discrimination typically occurs in pre-employment phase. In other words, job interviews, right? So, and many individuals who report that they've been discriminated against, it happens in this context when they go for job interviews and they're discriminated based on language. And many times language is used as a proxy to discriminate against race, nationality, religion. So in the job ads, typically we will see only applicants who can speak a particular language can apply, but that's really a proxy for saying we only want people of a certain race to apply. So now language will also be a protected characteristic, and we would anticipate that many complaints of discrimination will probably be based on that. Interestingly, we also see pregnancy and marital status on the list. Probably this will also generate some complaints. And the committee has recommended that the legislation specify that the protections apply to women who express a desire to get pregnant or get married. So this will be interesting because if a woman comes for a job interview and during the job interview, she shares that she intends to start a family soon, and her application is then rejected on this basis, I think that could generate a complaint, right? So that really requires companies and HR professionals at the interview stage to really think about what are the questions you're asking. Is it necessary to ask new hires what their family planning is? Do they plan to have kids in the future? I mean, because you ask the question and then you reject the employee, and then, you know, the employee may wonder whether that featured in that decision-making process, right? So unless necessary, I think, think about whether it's necessary to ask these questions, otherwise steer clear of asking such questions during the interview process. So of course, whenever we have rules, exceptions to the rules also apply, right? So if it's a genuine and reasonable job requirement, and let me just give a quick example. So if you're hiring for the role of a teacher in a school where the students are Chinese nationals, and it's a requirement to conduct the lessons in Mandarin, it would be deemed necessary that the teacher is fluent in Mandarin, right? So it wouldn't be a case of discrimination in that case to put up a job ad saying that, or to hire based on the fact that your candidate can speak Mandarin, right? As long as the advertisement is phrased and framed in that correct way. I'll expand on this a little bit later. There is also an exception for small firms with less than 25 employees. As we mentioned earlier, the government is rolling this out for larger companies for now. But I think really it's not that smaller companies are going to be exempt forever. I think this is just really to give smaller companies time to adjust, a longer runway. So if you're a smaller company, I think the message is that it's not that you can continue to discriminate on all of these factors, but you should start taking steps to improve your processes, because in time to come, we can imagine that this protections are going to apply across the board to all companies, all workers. Okay, so under the new legislation, employers will be required to establish an internal grievance handling policy and make it available to all employees so that they are aware of how to raise complaints in the event of workplace discrimination. This should be a thorough and well-documented process with fair investigation in order to comply. So in the case that the employee is unhappy with the outcomes and wishes to escalate this further, there will now be additional external paths available as well. So what are the external paths, right? Tripartite alliance will be the first step for employees who wish to escalate a claim outside of the internal process. There will now also be compulsory mediation to be undertaken by both parties. And finally, if parties are unable to reach an agreement, then the matter will be adjudicated. And this is where having a thorough and accurately documented internal procedure becomes highly important, because you will need to record the steps and actions taken to investigate in order to show that you've taken the complaint seriously and followed the necessary guidelines. Now, yeah. So we come to enforcement and remedies. There's no point having all of these new laws and policies in place if there's no enforcement mechanism. So previously, before all of this happened, right, before the new legislation comes into effect, as it stands now, if an employee has been discriminated against, there is investigation by MOM, and if MOM finds that this is endemic and the company has this practice, the only control lever that they had was really to curtail their work pass privileges. So the next time the company applies, maybe you don't get approved, right? But now under the new framework, there are going to be penalties as well, and other enforcement mechanisms. So the range of penalties, if we look at pre-employment claims, up to $5,000 compensation can be awarded. So this is really at the interview stage. If an employee complains that, or a potential candidate complains that they've been discriminated against and that is found to be true, then the company faces a compensation order of up to $5,000. Where it occurs within employment, the penalties are higher, between $20,000 to $30,000, up to $20,000, $30,000. For serious breaches, the state may conduct investigations and the company may also face enforcement action. And of course, we've got other penalties, corrective orders, work pass curtailment, and other financial penalties as well. Okay. So, in addition to the initial complaint procedure and requirement for a full internal investigation, there's also a recommendation for the new legislation to prescribe anti-retaliation provisions. Now, the government knows, MOM knows that this always, or not always, but this happens regularly. Employee makes a complaint, they investigate, and then many a times after the employee makes a complaint, they start getting targeted, and you've got their managers or their superiors retaliate against them by giving them maybe deductions to salary, deprivation of benefits, other forms of harassment, things like that. So the committee recommends that this be baked into the new legislation to explicitly prohibit retaliatory behavior. And this will cover all forms of punishing an employee or depriving them of opportunities because they made the complaint. So any kind of adverse decision made against an employee who has complained about workplace discrimination could fall under this category. So again, I think it's really important to ensure that full documentation during that process, so that as a company, HR department, you'll be able to show whatever the complaints were made and actions undertaken by management thereafter. And if you fail to comply and the employee is successful in their complaint about retaliatory actions, then enforcement action is very possible. Okay, we are almost reaching 11:40. I will just quickly go through a few case studies and then we can maybe open up for questions. So in the first case study, we've got a job seeker who applies to be a facilitator for a children's workshop. And during the interview process, the employer asks about the job seeker's age. And after the job seeker replies that she's 50 years old, the employer says that she's not suitable for the role, as they prefer a younger person who could be more energetic. So this, I think, quite clearly could amount to discrimination, because the employee has been excluded from consideration, or the candidate has been excluded from consideration for the role based on a protected characteristic, which is age. And in this scenario, age has nothing to do really with the functions of that role. So I think in this scenario, it will be quite obvious that it amounts to discrimination. Another example, job seeker is offered a role as a finance officer, and when undergoing pre-employment medical checkup, she is found to be pregnant, and the company subsequently retracts the offer, citing that the nature of the job is not suitable for a pregnant employee, even though it is a desk-bound role. Again, this could amount to discrimination. Unlikely that in the real world we will see the company explaining that she's been excluded because she's pregnant, but we can sort of imagine a scenario like this happening, where the employee goes for a pre-employment medical checkup and the company finds out that the employee is or the candidate is pregnant, and then they rescind the offer without giving any reasons. But even in that scenario where no reasons are given, I think that if the employee, the candidate, makes a complaint, the company will probably need to justify why that decision was made to retract the offer only after the medical checkup, right? You put two and two together, it appears that the decision was made because that employee was pregnant. Again, as mentioned earlier, it also protects applicants, women who express a desire to bear children. So again, think about what is the information you're collecting at the job interview? What information you're collecting from employees? Is there a need to be asking these questions? Okay, next. So in this case study, we've got a hiring manager who conducts a panel interview with two candidates for a job role. Candidate A is of the same race as the hiring manager. Candidate B is of a different race. The interview panel assesses and documents in its interview records that candidate B is more qualified for the role, but the hiring manager offers the job to candidate A as he feels more comfortable working with someone of the same race. Now, obviously, this is not going to be shared, right? So the hiring manager is not going to say that he's hiring candidate A because he's more comfortable with working with someone of the same race. But if it's documented that candidate B is more qualified for the role, then the question is, why is a hiring decision made to hire candidate A instead. So as a company, as a in HR, you wouldn't want to be in this situation. Again, it comes down to documenting reasons and documenting that process so that you can defend the decisions that you make, whether during the hiring process or throughout the employment. Okay. Are there any more case studies? I don't think so. Okay. So very quickly, what should we do differently? Check the language used during hiring processes. If you are requesting a certain language or ethnicity, you must justify it. I think we've covered this earlier. Also ensure your grievance handling policy is thorough and fair. Have a step-by-step process for investigating complaints, which is made, and this should be communicated to all employees. And make sure that your employees, especially those in decision-making roles, management, are educated on the recommendations from TAFAP, as well as the new legislation that will come in probably in the later part of this year. Okay.
All right.
Is there anything else? Yeah, okay. I think that brings me to the end of my presentation. I think, Sanam, we can go to questions if there are any.
Yeah, no, absolutely. We've had questions flooding in. It's quite interesting because they are quite heavily focused on the anti-discrimination legislation, obviously rightly so, because it's brand new and it's something that we haven't seen in the space in terms of protected characteristics. But I will kick off the questions. One of them actually is exactly what I was thinking, and I actually wrote down the question to ask, but I'm glad somebody asked this as well, which was around retaliation with anti-discrimination. What about if it comes from the employee that's said that they've been discriminated against? What happens in that case if they're kind of sending out bad, energy to the rest of the team and causing a lot of upset in the workplace?
Okay, interesting. So it wouldn't really be caught within this the new laws, because the anti-retaliation provisions in the new laws are to protect employees from being retaliated against by the employer. But that doesn't mean that the company is powerless. I suppose, to paint a scenario, and we've had, situations like this where clients come in and they tell us that, my this has happened and we've got a very toxic employee, and that employee hasn't been too pleased about certain decisions that have been made, and they're sending nasty emails to other colleagues, or they're trying to entice people to quit together with him or her. So it's all this behavior, right, where the employee is behaving in a retaliatory manner against the company for certain decisions that the company has quite fairly made, right? So in situations like this, actually, it comes back down to the employment agreement. In most employment, in the employer relationship, there is a duty of good faith as well, right? So as an employer, I owe a duty of good faith to my employee, but it's a two-way street. If I am an employee and I start conducting myself in a manner which harms the interests of my employer, then the employer may take this, depending on the circumstances, as a breach or a material breach of the employment relationship, the employment contract between the employee and employer. And that could be a basis, depending on the severity. And again, I think in that scenario, grievance handling is very important. If your employee is taking such steps, you do need to follow due process as well. If you want to fine and terminate that employee for misconduct, you can't just do it without having a due inquiry. You need to give that employee a chance to respond. You need to do an investigation as well. But long story short, I think the company, the employer, can take steps to terminate or take action against that employee if it is serious enough, if that employee is behaving in such a manner which harms the interests of the employer.
Yeah, I think definitely a lot of employers, they forget, and it's just because it's something that a lot of lawyers know, which is the duty of good faith. It's one thing that gets lost along the message because we're so focused on the parts of the law, but it is this overarching component that's in the employment agreements and that exists in the relationship. So you're absolutely right. And, it comes with the expertise, I think, Mato. But well, another question that we got in was actually around the bonuses that were discussed. So somebody asked if the bonus is referring to PB in addition to AWS, or if it was one or the other.
Sorry, the bonus?
The bonuses that were discussed, I think earlier on, maybe Elizabeth, you might have spoken about them. If not, we'll move on to the next one. Just I'll go back and find out which slide it was specifically relating to, and then we'll keep talking about discrimination because it seems like it's the hot button topic. Yeah. So somebody has also asked around discrimination. So it may not be obvious, which I think this is really, really interesting. So it may not be obvious all the time that you've rejected a candidate based off of, a particular maybe set of skills that they don't have or anything like that. And it may look like it was discriminatory and that you've done, something against the protected characteristics. How do you handle those cases? Is there anything that the employer should keep on file, or the HR manager? What should they do?
Yeah, so I think documenting decisions is very important. And if you are, let's say interviewing a candidate or conducting a performance review of an existing employee, right? Decisions should be documented. His or her performance should be documented. The fact that you have communicated that this employee is perhaps not performing so well, right? That should be communicated to the employee and documented as well. And you should be prepared to, well, I always tell my clients this, right? Conduct yourself in a manner where you hope that you're not going to get sued. But if you do get sued, you do have the documentation to justify the decisions that you've made. Yeah, I think that encapsulates it.
I think that's a good policy to live by. I think for all employers, definitely take note of that, because they always say, anything that you have, anything that you've got in writing, always make sure that it's written well so that it can be presented in court and you feel a lot more comfortable with it if it goes to litigation. So it is really important to have all of that. A couple of questions came in around pregnant employees and that protected characteristic. So one of them is around terminating a pregnant employee if they are taking too much time off for checkups and things like that. I feel like I know the answer to this question, but I'll let you answer it, Mato.
Yeah. Short answer is no, you can't do that. And that's not something new. There are already provisions in place which say you cannot terminate a pregnant employee during the period of pregnancy, right? So, yeah, that's a big no-no.
And what about a resignation? Can you ask the employee to resign as an ultimatum?
So that is what we call at law a constructive dismissal. You ask the employee to resign. I mean, if the employee resigns on their own volition, that's fine. You've not had anything to do with that resignation. But if you make the circumstances so oppressive that the employee is forced to resign, or you tell the employee you better resign, otherwise, we'll terminate you. That's what we call a constructive dismissal. So even though you've got a resignation letter from the employee, it can still be challenged. Yeah. And if it is found to be, you can't justify it, and it appears that as an employer, you forced your employee into resigning, then it will be deemed to be a dismissal instead.
We always say the best approach is do not compel an employee to resign, so don't force them, and also make sure that you're not giving them ultimatums. You know,
Yeah.
we'll send you out the door as long as or you can resign, either one. So it's always a better situation not to do that. We have a lot more questions actually. I lie if I say a few more, but we do have some around again around the anti-discrimination side. So there was one here that says, why is non-discriminatory law not to be enforced to companies with less than 6 employees at present? And I think it might have gone back to the idea that smaller businesses need a bit more time to prepare, maybe?
Yeah. Yeah.
Okay, perfect. So all right, and then we've got another one around, so on workplace fairness, can application forms ask for date of birth, nationality, and that kind of information? And what happens with that data? Are we, are employers allowed to keep that data?
So the short answer is yes. Look, you can ask whatever questions you want to ask if there's a purpose for it, right? So if you are working in a, let's say, an industry where you require, let's say you're hiring personal trainers, right? And that's your business, and you have a 70-year-old employee coming in. I don't know whether, so of course, if that employee or that candidate is old, but he's still very fit and he's been a personal trainer for many years, and you discriminate based on age, that's still wrong, right? But if you have a situation where you need to ask about the age, about his medical history, so on and so forth, because of a function of the job that you are hiring for, then I think it is fair, right? So I think the approach to this has to be, what is the role that we are hiring for? What are our needs, right, for this role? What functions does the candidate need to perform? What attributes is essential for this role? And then let that guide you in determining the questions that you're going to ask the employee.
That makes sense. And in terms of, I guess, the questions and the data, and when it comes to privacy with employment law, how is there any parameters around how this data needs to be collected or kept? I know privacy and data collection is always a really big topic. So, but is there any kind of parameters or advice that you would give around that?
Yeah, so that's a different topic altogether on data protection, and we can have a whole another hour on that. But yes, I think employers, companies need to start taking data protection more seriously, because the authorities are, right? And we've got the PDPC, the Data Protection Council, which we've been seeing the legislation grow, penalties increasing, and enforcement action increasing as well whenever there are data breaches. So the golden rule or rules for data privacy are always consent and purpose, right? So you have to always ensure that you are obtaining informed consent at various stages. Consent for the collection of personal data, consent for the retention and use of personal data, right? And ensure that the purpose or what is done with the collection of the data is for the purpose which has been communicated to the person that you're collecting that personal data from. So if this is employees, and companies will invariably have to collect sensitive information, personal information from employees, sometimes including medical information, right? Including potentially information about their family members as well. whether they have children, so on and so forth, their spouses, in more sensitive roles, what their spouses work as well. So you are collecting a lot of information from your employees, highly sensitive in nature. You need to ensure that consent is obtained, and that can be done through the employment agreement. And it is collected for a specific purpose, and what is done with that information is aligned with the purpose for which you collect it for. And also do audits from time to time. Do I still need to be retaining this information 6 years after that employee has left? Probably not, right? So I think these are things to think about.
No.
I just noticed that I've been answering all the questions. I'm not sure if Elizabeth has anything else to add on to that.
I will maybe Elizabeth, while you're here, and this is a good segue. So that question, the person that asked that question around the bonuses did clarify, and they said it related to the topics that you were talking about, which is referring to PB as well as the AWS bonuses when we were talking about, I guess, the skills bonus and the different criteria. Yeah. So does that resonate? Because it seems it's a little bit harder when there's acronyms, I think.
Yeah. So I think could you just repeat the question so I could, because
Yes.
I think they're talking about the skills bonus,
Yes.
but what specifically in relation to AWS?
So is the bonus referring to PB in addition to AWS as well?
Okay, I'm not sure I understand that question completely, but I think insofar as the skills bonus is concerned, it is really in relation to so first identifying whether there's a shortage of that, and then you, depending on the employees, your diversity factors within the firm, it depends whether you score an additional 10 or 20 points. So I'm not entirely sure if that clarifies or answers that question. But yeah. Elizabeth,
I think it does.
anything else to add on to that?
Yeah, no, I think that definitely clarified most of it. I can see that the question isn't popping up again, so that's that's good. And I guess before we finish it up, I'll just do one more question. Hopefully this one will be a quicker one. It's do we need to compensate employees under the WICA or the WICA if they are under a probation, if they are still under probation?
Under WICA. Okay, so if that employee, and I think I'll need to get back to you on that one, because generally under WICA, if there is a injury that has taken place or workplace accident, and the employee suffers any injury and their medical bills, so on and so forth, then WICA, a claim can be made under WICA. Whether an employee who is still under probation qualifies, I'll need to get back to you on that. I don't have an immediate answer.
Okay, that is perfectly fine, because we will be sending out any questions that we didn't get to, including this one as well, just as part of the information after the webinar. So Elizabeth, if I can get you to just go to the next slide. I just want to put up your details and all of the information on there. So I think what we'll do is we'll wrap it up now, because we're reaching the end of the Q&A component, but there are still a lot of questions that we haven't gotten through. So like I said, we will get to them afterwards, and we'll send out some materials as well to everyone that has registered. So thank you everyone for joining us today. It was definitely an interesting one. I'm glad that we've spent a lot of time speaking about the anti-discrimination topic, because it seems like there are a lot of questions coming in. A lot of employers feel uncertain about that area. And just to keep in mind as well that a survey will pop up and launch after the webinar. We would love for you to participate just so that we know, if we need to improve on anything or if there's any areas that you particularly liked. So that will be really great feedback for us. And like I said, we'll be sending out more information afterwards. Mato, Elizabeth, thank you so much. It has been amazing having you here. Sorry if I threw some curvy and curly questions at you, but you handled them with ease. So I really appreciate that.
Thank you very much, Sanam. It was, again, a treat to be here, and we are so glad that we had the opportunity to talk about these topics here today.
Yes, no, definitely. And don't worry, everyone, we'll be back again with more, I'm sure. So thank you so much. Hope everyone has a lovely afternoon now. And thank you. We'll see you in the next one then.